The first trans member of Congress. He identifies himself as Sarah McBride. His real name is Tim McBride. So little Timmy is now going to be a member of Congress in January. And little Timmy thinks he's going to come in and stand at a, we don't have urinals in the ladies' room. He's going to be standing in a toilet apparently and trying to use the restroom with the rest of us women. Let me tell you, this is an assault. I'm not kidding you. It is like a physical assault for a man to come in, charging into our private places, bathrooms, locker rooms, our gyms, places that are designated specifically for women only,
Does he get
not for men.
to work out in the gym of the House
He
of the
can
Women?
go to the members' gym, which is both sexes can go to the members' gym. But there is a women's gym. He cannot go in there. That is where our showers and locker rooms are, and there are not doors to the shower room. And anyways, he doesn't belong in there, period. And so my specific question was, are we as women going to be left to physically defend ourselves from a man that has no respect for us as women? And as a matter of fact, is so sick and mentally ill that he thinks he's a woman, dresses like a woman, calls himself a woman, and has the audacity to come and charge in. That's an assault. I see it as a physical assault when he is coming in our bathroom where we are in a position of weakness. That is absolutely unacceptable. I asked Speaker Johnson what the men, we our top three in leadership are men. Our speaker, our leader, and our whip. All three men. It's time for men in this country to defend women from these sick, mentally ill men. I am so fed up with it, Steve. Thankfully, I'm going to report to all of you, Speaker Johnson said there will be no biological men in our bathrooms and women's private spaces.
So
I am thrilled. Yes, and I'm thankful. And I will report that. That's what he told our entire conference this morning when I asked him that question, because I love what Nancy Mace is trying to do with the resolution, but the resolution is not binding. A resolution is simply Congress making a statement. So if that were to pass, and I hope it does, I do support her resolution, but it's not binding. We have to put it in the House rules next Congress and end this once and for all.
It's called the so-called Equal Rights Amendment, Proposition 1, or ERA. It was recently passed by voters. And it's, despite its name, the ERA places women's rights in danger, right? It's the Equal Rights Amendment. I was thinking, yeah, the ERA, this is good for women. It actually puts them in danger, despite its name. So it's by eroding the ability to have single-sex spaces, as well as undercut parental rights, eviscerates religious liberty, and legalizes certain discrimination. Other than that, I'm sure it's a great proposition. Now let's talk about that. Here's the actual text of the ERA, and this is paragraph B. Revises the legal meaning of discrimination. With the amended language highlighted, so I'll let you know when how it changes. So Article 11A says, will say, no person shall be denied the equal protection of the law of this state or any subdivision thereof. No person shall, because of race, color, and then here's some of the ones added. Ethnicity, national origin, age, disability, then creed was already there, or religion is already there. Then it says, and this was also added, or sex, including sexual orientation, gender identity, gender expression. Think how broad that is. Like, no, I was just expressing my, gender expression, pregnancy outcomes, and reproductive health care autonomy. Be subject to any discrimination in his or in their civil rights by any other person or by any firm, corporation, or institution, or by the state or any agency or subdivision of the state pursuant to law. Now it also added this. It says, nothing in this section shall invalidate or prevent the adoption of any law, regulation, program, or practice that is designed to prevent or dismantle discrimination on the basis of a characteristic listed in this section, nor shall any characteristic listed in this section be interpreted to interfere with, limit, or deny the civil rights of any person based upon any other characteristic identified in this section. So this is really broad. This is, attorneys wrote this, knew what they were doing. Let's just make this so broad. And so that's what we're dealing with. And it's interesting because in the language, talks about pregnancy outcomes. Interesting. So that itself could be actually very broad in terms of abortion, but also what about a scenario where you have where the baby's born and the parents say, I thought it was going to be a girl, kill it. The child's handicapped, kill it. So this gives us some breadth. In California, we have a law, and it's outrageous, where it says you can kill a baby for pregnancy-related issues up to 28 days after the baby's born. And now you have some mothers, people say, well, what mother would do that? Well, let's say a mother may be mentally ill, or let's just say they've had their baby and they're in deep depression. Now, I know that doesn't happen to women when they have, no. I remember, I almost say it's too close to home, but anyway, but that's reality. You can have some issues there, and in California, you can actually kill the baby for up to 28 days after pregnancy, and a coronary person doing the coroner's office, they are not allowed to investigate, and if they do, they could face heavy fines. So, yeah, very disgusting. So this is a concern that I have with this kind of language that's on there, but it's very, very dangerous, and it's very broad. We're going to talk a little bit more about some of those other terms a little later as we progress. So let's take a look at the text of the ballot measure. Now, this is the ballot measure. So despite its sweeping language and drastic legal implications, Proposition 1 on the ballot measure appeared on the ballot as follows. This is what it said on the ballot measure. It says, the proposal would protect against unequal treatment based on ethnicity, national origin, race, or age, disability, and sex, including sexual orientation, gender identity, and pregnancy. It also protects against unequal treatment based on reproductive health care and autonomy. So note that neither the ballot measure nor the actual text of the amendment includes the word abortion anywhere. Also, the ballot measure does not in any way mention the discrimination language that was actually in the paragraph that I read. So this is that just now. So this is a real concern, and yet this is what they can do because they have great discretion in terms of the language that's put in as far as ballot measures. A stealth campaign of abortion rights. This is one of the major complaints about this was that it was the Equal Rights Amendment part. It was really just a whipped up support under the guise that the measure was going to protect abortion access. So what they did is they focused on abortion access, but the real goal and purpose was to bring in all of this new Pandora's box. Did you have a question?
Yeah. The last, the words that they added, like the sex, ethnicity, nation of growth, there was one part at the end there that was outcome of pregnancy. Would that be considered the abortion part?
Yeah. I mean, oh yeah, you could have that arguably.
What else would that mean?
Yeah. Pregnancy outcomes, but it can apply to, like I said, you have a baby that is, let's say abortion happens and the baby's still alive. The parent has the ability to decide, the outcomes. It's very broad. It's broader than just abortion. But the point is that abortion is what they used as their rallying cry. This is for a woman's right. Come and vote for it. And they vote for it, and what they voted for is a lot more than just that. So anyway, and here's why it really wasn't even necessary. So, we heard about, the Dobbs decision. Supreme Court overturned Roe versus Wade. Well, here's the kicker. Abortion was already legal in New York in 1970, 3 years before Roe versus Wade. So it's not like, now abortion is legal here. It was legal here before Roe versus Wade was overturned, or Roe versus Wade came down and had its horrific decision, pro-abortion decision. In fact, Proposition 1 does nothing to actually protect abortion access in New York. Rather, the measure can be described as a bait and switch on the public. That's what you got. And so, anyway, the language is cleverly worded to hide an agenda that most people oppose. For example, if there was a single issue vote on whether reverse discrimination should be added to the state constitution, how many of you think that would pass? Like, yes, this affirms reverse discrimination. No, it wouldn't have passed, right? I don't think it would have here in New York. And then similarly, it's unlikely that voters would agree that biological males should have the constitutional right to play in women's sports. No. Or that minor children should have the right to make life-altering medical decisions without parents' knowledge or consent. That wouldn't have passed. But that's what this was all about. And it definitely passed. Apparently it wasn't even close, as I understand it, which is a real shame. Huh? 2-1. Yeah. Yeah, so it was unbelievable. Moreover, the ERA has been widely criticized as being vague, overly broad, and open to judicial interpretation, and likely to lead to lengthy court battles over existing laws. So who is really happy about that part? Lawyers. Right? Because they're going to be able to file suits, and other lawyers need to chat back and forth. It's going to cost the state of New York a hefty sum. There's just so much open for interpretation. So really, it's the New York courts, not the legislature, in the end, that's going to make these final decisions on irreconcilable differences between classes, such as sincerely held religious beliefs and gender identity. Because they're both, protected rights, and it just sort of opens this door when they're bucking heads. How's this supposed to turn out? Well, when they're bucking heads in this context, how's it supposed to turn out? So it's going to result in more litigation. Now, what's the potential impact? I guess I ran out of time, so I'm just teasing. Because this is the most important part as far as I'm concerned. Yes?
Do you think that it will also increase the number of arrests of innocent people that would have been defined previously as innocent? Like parents will be arrested for disagreeing with the child changing their...
Yeah, we're going to talk about that.
Okay.
Because you're actually absolutely right. And I'm going to talk about that in just a second here. So let's talk about some of these impacts involving some of these categories that have been added. So let's start with age. Okay, so most people think of age. What do you think of? Age discrimination. You think of what? Old people. Not like anyone here, but, I got the gray, so I could... But yeah, I always think of old people. We at Pacific Justice, we've defended elderly people who were, the state was going to have them basically put to death prematurely because of their quality of life. This is where some medicine has gone, and we had to go into court and halt it and say, no, stop the drugs, let her live a healthy life. This one case, lady, she was actually 99 years old. It sounds too much like it's something you just make up. She's 99 years old. I wish she was 97. It just, she was 99. She was under the care, the guardianship of the state of California. The state put her on hospice and put her on all this medication and these drugs. And she was being cared for, and she was real limp, and, and her daughter saw her and says, what is going on? And her daughter went in and she got custody of the mother. And she said, off with these drugs. And guess what? The mother bounced back. And she started baking and cooking meals and going shopping. And she, for a whole nother year, lived actually a healthy life. But that's just an example of those things where they try to put people down. And we had other cases like that. But this is dealing, though, not just with elderly, but actually it leaves open the door to argue that children can be deemed victims of age discrimination, because it doesn't say just elderly. So the creation of age as a protected class, coupled with the protections of gender identity and healthcare autonomy, will likely result in the removal of parental consent from health decisions impacting their children, and grant minor children the right to transgender surgeries and other types of medical interventions, all without parental notification or consent. So parents don't even have to know about it. That's what this kind of language arguably would be able to do. And I frankly, I would fight it. We will fight it. But this is what we can see this being used at. It's very slickly drafted. Yes.
Can the state force the parents to pay for that?
State force the parents to pay for that. I don't know the answer to that. That's a good question. Good question. But for a bill of just I can answer. No, I'm teasing. No. That was a lawyer joke. Okay. All right. But that's a good question. But I can see that happening because when children are taken by the government and given, quote, care, the parents are liable for that. So I would say, for the sake of argument, that it's very conceivable that parents could be forced to pay for that, even though the parents were against it. And if not the parents and or the taxpayers. Yeah, the child, I guess, the 11-year-old, yeah, probably not. Now, I want to give you an example of how this is very real. In Placer County, California, this is one example. We're seeing these all over the country now. This is where social workers are taking children from families where they want to, the child expresses some concern, or they think they're a different gender. Social worker takes the child from the parents. This happened in Placer County. One girl, young teenager, told her friend that she thinks she feels like she's a boy. This is early adolescence, you know. Well, kids are still working on figuring things out. So this friend told the teacher told the school counselor called CPS, social workers. And the social worker came to the family, knocked on the door and says, are you aware that your daughter has a different gender identity? Are you willing to affirm her new gender identity as a boy? They said, no. We know what she's talking about, but we're a Christian family, and we're going to take care of her. We're going to get her Christian counseling, and she's going to learn a biblical perspective so she can work through this, and we're going to love our daughter, work it through with her so she can not believe this lie. The social worker says, oh, no, you're not. Here's the judge warrant. I'm taking your daughter. And they did. And she's put in a foster care home. And they were already scheduled. They went into court to get guardianship. The state of California, Governor Gavin Newsom, this is his racket, to get guardianship and then start the injections immediately. And then the surgical procedure. So we at Pacific Justice Institute heard about this. Family contacted us. We went right into court and we got it halted. No injection, no surgery. And she was still in foster care. And it took over 2 years of litigating before the judge finally says, yeah, the daughter needs to give back to the parents and the family. And at that hearing, the daughter said, Your Honor, I just want to want the court to know that I really don't feel like I'm a boy anymore. Had we not intervened, what would have happened to her? She would have been permanently sterilized. That's what the injections do from a 3 to 6 month period of time. Sterilization. It would have been so tragic. So then what would happen to her mentally, what the stats are? Kids who are affirmed into gender confusion have a suicide rate more than 12 times that of the average adolescent, which is already high. A child actually has a better chance of living to see their 30th birthday if they're struggling with leukemia. They actually have a better survival rate than if they're affirmed into gender confusion. So why do we do that? You know, it's insane. Yes?
Is there any way to sue these agencies?
To sue?
These agencies?
The agencies, no, we can go into court like we did and get the protection. So we can do that. And if we have to appeal, we can. And there's a certain level where you can hit them with attorney fees, potentially, but not in this kind of a scenario. But on the litigation side, we do see public schools as being very vulnerable to what they're doing, which is secretly grooming children without parents knowing about it. And in fact, let me talk about that. In New Jersey, right now, the Attorney General ordered all public school teachers, every one of them, to not only use pronouns that may violate their conscience, and even with any kind of decency, it will violate your conscience. It's just wrong to encourage confusion on any child, vulnerable child, right? Of any kind, much less confusion that is so fatal and permanent and harmful. But the Attorney General says, no, it doesn't matter about your conscience, your religion. You have to use these pronouns if the child says they want to be affirmed in this other way. Like the opposite gender. But he didn't stop there. He also said, oh, and by the way, if parents ever ask you, lie. Lie. Yeah, and that's New Jersey. But other blue states, New York, you guys are very vulnerable. The same way. California, standard operating procedure. In fact, our governor, they just signed a law saying that public schools, even if you have a friendly school board that's pro-parent, they say, no. Those school boards, you can't do anything on this. And in fact, a teacher that is caught secretly grooming a child for gender confusion, they're completely immune from any action, and they cannot be stopped or halted or punished for doing so by any school board. That's Governor Gavin Newsom. Just remember that in 2028. Why did that year come to my mind? I wonder what's about 2000. Okay. All right. You guys get it? Okay, never mind. All right. But anyway, so that's very real. So we're litigating. We have an office in Trenton. Karen White is our saber-toothed tiger. She's a great litigator, and she's representing some very upset parents and also public schools in that area, in that state. Let's talk about sex.
Can I ask a quick question?
Oh, sure.
Are they creating any coalitions, the parents, to fight this?
In New Jersey, yes.
Okay.
That's what we're
Going
representing.
after policy as well?
Yeah.
What are they doing?
With the stating that the Attorney General cannot command this because this violates, number one, the rights of parents, and number two, the free exercise rights of the teacher and the Title VII rights of teachers not to have to not be reasonably accommodated for their religious beliefs and conscience. So, yeah, it's a good case.
So if that happened in New York State with this Prop 1 though, you wouldn't have potentially better outcomes, it would be worse. Because they'd all be protected and
Oh,
here's what I'm gonna
very good question. I'm going to answer that. So, Prop 1 amends the state constitution of New York, but the federal constitution trumps the state constitution when they disagree. So we still have the free exercise clause on the First Amendment, which is what we're using in New Jersey. So states can get as wacky as they want. They can't, they're still under the constraints of the U.S. Constitution. And so that's our confidence, as well as federal law and federal legislation. And we're going to see some great legislation coming down within the first 90 days, or the first 2 years of the Trump administration. Some great legislation. I believe it's going to be addressing a lot of these issues. And I know we're very supportive of those efforts. So it's tragic, but that's what we're dealing with in terms of age. Now let's talk about sex. The ERA puts biological sex at the same anti-discrimination level as characteristics like race and religion. The measure establishes strict scrutiny. Strict scrutiny is the highest level of protection allowed. That's what they're giving based on sex and biology. That would, it's interesting. So gender-based discrimination under the 14th Amendment, Equal Protection Clause, gender discrimination, that's given a mid-tier level of scrutiny. But this takes gender, but not just gender, but gender identity, sexuality, sexual orientation, gives it the highest level of protection, right along with the ability to go to church on Sunday, right? Or synagogue. Yes?
Does that protect pedophilia and pedophiles then?
Potentially.
Sexual orientation?
Potentially.
And man-boy?
Yeah, potentially. I'm not saying it does because it's vague, but yeah, I can see that. It's a plausible argument, plausible application. Now, so this high protection, it would bring an end to many spaces, services, and opportunities that were established for the benefit of a woman, like scholarships, same-sex schools, or woman-only professional associations. So that's going to be very complicated and very problematic. And then we have gender identity. It's also like women's sports. I mentioned that's another example where that kicks in. But now gender identity, the RA creates a conflict between the rights of women and the rights of men who claim to be women. In any sex-specific space that survived the strict scrutiny test, men would be able to opt in to that space by simply claiming to identify as a woman. That's all that's needed. It doesn't say you have to have surgical procedures, doesn't say you have to affirm this and be certified by a psychiatrist, that say you have an incurable condition. No, just you affirm it, you say it. So that's very, very problematic. Let me give you an example of the kind of case this would apply to. We have a case dealing with a Korean woman's spa in Seattle. The Seattle area, it's Olympia, Seattle. And it's run by Christians, strong Christians, Koreans, and they have this Korean women's spa. Well, a man calls them on the phone and says, I identify as a woman, and I just want. What are your hours? I want to go in there. They said, are you biologically a woman? Or he goes, well, I identify as a woman. They can tell by his voice. There's a difference between male and female voices. Usually, okay, usually. Michael Jackson, his voice was so high, but that's just beside the point. Okay. So they said, no, we cannot do that, because a Korean spa, you go in, you're naked, completely naked. So they don't mix the two, right? And they said, look, we have mothers and their teenage daughters in there. Absolutely not. We can't let you strip and be naked in front of them and look at them as they're naked. That's criminal, which is really so ironic. Lewdness is a criminal statute. You have a flasher, it's a crime. But how's it different in this other context? It's very, very problematic. So the Washington Human Rights Commission, what did they do? This is like George Orwell. They say what they mean, but they really mean the opposite. That's what they are. So they have brought an action to shut down this Korean spa. We at Pacific Justice Institute, we stepped up. And we don't get angry at PJI. We don't get angry. We just sue. So that's what we did. That usually gets one or two laughs somewhere. Okay, good. Thank you. So and most things we get resolved without litigation, so don't get me wrong. In fact, but when we have to, we sue. So we did. And just this week, this was oral argument was heard before the Ninth Circuit Court of Appeals. Our Chief Counsel, Kevin Snyder, I saw him on my computer screen. arguing the case. And there was one judge who's Korean, who's been in a Korean spa before. He was very had great questions, for the other side, against the other side, really good logical questions. And so we're pleased with him. The other justice, though, she was like treating this like Rosa Parks. Like the man is like, Rosa Parks, like it's like a black person being put on the back of a bus. And this is, that was how she saw this. I thought, anyway, there's a lot of things I thought, but this is being recorded, so I'm going to leave it at that. So, very frustrating. And then the judge in the middle, very elderly gentleman, distinguished gentleman. We're not sure. I don't know which way he's going to go. So we'll have to see how that turns out. Also, with regard to gender identity, and we had another case that was argued on the appellate court in Oregon. And this is to challenge Oregon's policy that says that if you adopt a child or a foster parent in the state of Oregon, then in order to do so, you have to agree to set your faith aside and affirm and encourage a child who has gender confusion, if they turn out to have gender confusion, hypothetically, purely hypothetically. And so basically it truncates the ability for a Christian couple to adopt or be foster parents through the state in Oregon. Period. So Ray Hackey argued that on appeal in the appellate court in Oregon. Did a really good job. So hopefully we're going to get a favorable opinion. We'll see. Yes, sir.
So the Korean lady in Washington, right? That was like 3 years ago, 4 years? This has been going on for a while.
Oh yeah, that's why it's Ninth Circuit. It's at the Ninth Circuit
Been
level.
able to operate her business?
No, I don't believe so.
So, I mean, so that really basically shut her business down, right?
That is my understanding.
So she could sue the state of Washington if she wins, I would hope. For loss of income and...
For damages, that's a possibility. Yeah. So.
It's horrible, yeah.
Oh, it is. It's terrible. Very terrible. So yeah, very good observation. These are. It's not just you're right. There's implications to these things and real loss, heavy loss. Healthcare autonomy. Let's talk about that. I'm sort of limited on time here, so I want to be respectful. Healthcare autonomy. This includes healthcare. This autonomy it paves the way for assisted suicide. Right? Do you see assisted suicide anywhere in the language? No. But it's so broad for it to not only to become just legal, but the standard medical practice. And so even in cases where a patient is not suffering from a terminal disease, okay, or where death is not imminent, this right to autonomy would arguably give those merely a despondent individual a right to die. And mind you, when you're talking about health care, it's not just physical, it's also mental health care. So we already have states that have adopted assisted suicide statutes like Oregon has. Yes?
Any way that could also be used to say, I want alternative care, I want, some other mode of care? I mean, does that allow that also?
Like what kind of alternative care? Like?
I don't want cancer treatment, I want this plant or something, I don't know.
Yeah, maybe holistic or experimental or herbal or something like that. Anything?
I'm just saying, does that open the door for that?
Yeah, possibly. I'd say it's very, very broad.
That's what I mean.
Yeah, extremely, very, very broad. Yeah. So, that's very, very problematic. Then there's national origin. This is our fifth category we're going to look at. You say, that's good, national origin. Why should we discriminate? Well, there are concerns that the inclusion of national origin as a protected class will allow illegal immigrants and non-citizens to receive the same benefits as New York citizens. And which arguably include the right to vote, at least in state races, state elections, the right to taxpayer-funded welfare, healthcare benefits. So that's what's opened up there. It's very, very, very serious. So the implications of the ERA in New York are very widespread. And now that it's passed, we are likely going to see other liberal leaning states do the same. In fact, Minnesota and Oregon have already expressed and announced that they're looking to put a similar initiatives on the ballot in 2026. So that's what we're looking at. These are blue states, predominantly. And there is I would say there's more of a distinction between a blue state and a red state than ever in my lifetime. They're just going in totally different directions. And fortunately, we still have the freedom to be able to live wherever we want. So it's nice to have that back door. That said, I don't encourage people to abandon their state. Because if we do that, then there's not much hope for change. So I really salute all of you who are staying here in New York. And the fact that I'm moving to Texas next month. I'm moving to Texas. I used to live in Texas, by the way. And you know what? There's a reason why Texans are so serious about their faith. Do you know why? Because every summer they're reminded where they go if they don't go to heaven. That's all I'm saying. Okay. Yes, sir.
I have one thing. With the identifying thing, I think if we flipped it, because my children are not vaccinated, so in 2019 they threw out 24,000 children in New York. We get all those kids, put on the T-shirts that I identify as vaxxed and send them back to school.
Interesting.
They want to pass this proposal, right? Prop 1?
Yeah,
Why can't that work?
and healthcare autonomy. You know, you can make the argument in defending someone where they have vaccine mandates. That's an argument you could make. I don't know if it could be used in a positive way in that regard. In California, it's interesting. So, California, they passed a law that says every child must be vaxxed to go to school, private school or public school. They have to be fully vaxxed. Yeah, but they said, however, one legislator says, well, you don't know what the new vaccines are going to be. You know what the risk element is. They said, oh, okay. So this is in 2015. So they said, for every vaccine that's been approved up till now, 2015, this applies to. Anything after this, you still can have a religious exemption. And little did they know that there was going to be a controversial vaccination for COVID-19 that was going to pop up. And we were able to use that differentiation to save thousands and thousands of children from being forcefully vaxxed. And we all know that since that vax, we all know, unfortunately, that from the age of 12 to 19, there's been a more than 13,000% increase in myocarditis for children ages between 12 and 19. So we at PJI were very, very pleased that we were able to use that language to very aggressively halt school districts, rogue school districts, trying to compel little children to have to take it. But so that arguably could possibly be used down the road here in New York as a defense to that, but we'll have to see. We are the lead organization for parental rights protection in the United States, with all our offices and our attorneys and our cases, and New York's keeping us busy. So, any other questions, or anyone I can sue? I mean, anyone we could help? Yes. You laughed on that one. That was good.
There's absolutely no way to stop this, because so many people had no idea what they were voting for. I mean, my brother's son voted yes, and my brother was talking to him, and he goes, I didn't know I was voting for any of that. So there's so many people that had no idea.
I know. Now, arguably what you could have down the road is a constitutional amendment. Of course, it takes money and financial backing for it. I know in California you have to at least $1 million to get the signatures to get on ballot in the first place. But arguably you could come up with another proposition that effectively truncates a lot of what we just talked about.
Could you sue? Could you bring it to any higher court?
Oh, it's like sue? Yeah, so some of these things...
People had no idea what they were really...
Oh, that? No. No, voter ignorance is, I've never seen, so far I've never seen that as a defense. I don't think we'll ever will. There's just a presumption that voters are assumed to take their responsibility seriously, et cetera. But just a lot of people were deceived, you know? Yes.
So it's not against the law to deceive people. I think that's 2008, Obama had a law passed, I can't remember. Is it 1020? Is the number, I don't think, where you're allowed to lie or deceive or propagandize the public.
Yeah. I just don't, it's very broad, and I don't think that would, I think it'd be really difficult practically to apply that.
But that has
You know.
to come down federally.
Yeah, but you know,
Why people are talking about it.
I'm just glad on a federal level we don't have legislation that's like openly, blatantly deceptive, like the Inflation Protection Act, was that? Which was like nothing with inflation, it only created more inflation. But they do. It's just, they just take it's an insult to the American people. Yes, ma'am.
So what about attacking it constitutionally?
Yes. Thank you. So that's what we at Pacific Justice are going to be doing. Now, some people say, why not just file a lawsuit and challenge all this stuff as unconstitutional? We could do that. We can challenge it on its face. So I'm glad you asked that question. However, the primary defense on the other side, when you just attack it on its face, we say, Your Honor, this can be used for this and this and this. And the other side is going to come back and say, oh, no, Your Honor. No, that was never the intent of it. And I think that's a huge presumption. No, Your Honor, wait, that's not what it's going to do. And now, you know, that's just mere conjecture. It's a speculation. And courts will then say, dismissed. We don't give judgments on speculation. So what you need to do, what you have to do is challenge it not only on its face, but actually also as applied. And that means we need people with circumstances that are dealing with this, and having this used as a justification for specific outcomes. It's sometimes it takes time to get those challenges, but as they implement it, as these things come up, we've got your back here in New York. We've got the offices here. So.
But we have to wait for people to be destroyed first.
Yeah, I guess, or threatened, imminently or directly threatened in some way, depending on what the fact pattern is here and what we're talking about. But that's where we're at. We see it. It can be challenged as applied and on its face. That's one route. Another route is for the people of New York to get together and put another proposition on the ballot that reverses the ugly stuff that most New Yorkers would reverse. Another avenue is to have a lot of this truncated, potentially the application truncated by legislation by the newly elected House and Senate and President of the United States. That is very promising. So those are some, and also another avenue is as far as on litigating, that we can get things removed is if you can say that something is void for vagueness, that's actually a defense to have something not apply. We can say, Your Honor, this language is void. It is for vagueness. What do they mean by X, Y, and Z? Or what do they mean by autonomous? Your Honor, these terms are not, articulated. So that's another defense in the litigation that could be used potentially to challenge it. So
What do you think the best defense is? What is your plan? You have a strategy. What do you think is the best way to approach it?
Well, I can say we at PJI, like I said, I told you about our different divisions. So the Church Engagement Division will be happy to work with your churches to help get the information out. If it gets back on the ballot again, if we get, there's petitions, we'll be working with the churches to help distribute the petitions so that people can sign and get it on the ballot. I mean, if someone takes the lead, they have to take the lead on that, but you can be assured we'll be happy to assist on that end. On terms of legislation, I don't believe there's much on the state level, from what I understand, with New York that we could accomplish. That's just from an outsider opinion. I may be wrong. But in terms of federal legislation, yeah, we're going to be actively engaged. In fact, the attorney who's in charge of this, Janice Laura, who's over the legislative division, she's now shifting to help make sure that some of these bills and things are addressed by Congress. So that's on that. And then on the litigation, as I said, as applied, we'll take these cases up and we'll be happy to challenge it on constitutional grounds or federal statutory grounds. So, and we're going to have some great federal statutes that we'll be able to use after the next 2 years, I'm sure. So, yes, ma'am.
Are people looking, or any of you people looking into the language that would be used for the petition that would go to the churches to circulate?
No, this is just conjecture on my part. I don't know.
Okay, or a counter proposition?
Yeah, I'm just speaking this as a thought. There's nothing beyond it more than just a thought. But, it takes, maybe there's an organization here in New York that's a policy organization that would love to do it. We'd be happy to work with them, use our legal expertise to assist. But yeah, that's where that's at. But the biggest opportunity is federal legislation. That's right there. That's very close and very imminent. So I see great opportunities there. And Janice Laura is working on it. She's a great attorney out of our Delaware office. So by the way, did everyone fill out that form, that half sheet? You guys all get that? Did everyone get one? Did anyone not get one? Raise your hand if you didn't get one, the half sheet. Raise your hand high if you didn't get one. Okay, good. I guess everyone got them. So if you guys could be so kind as to fill those out. It mean a lot to me personally to be able to keep you updated. We've got to work together. We need to, and we want to keep you guys updated. And if you want to support us on a one-time or monthly basis, that is fantastic. We appreciate the ammunition because we do our work without charge. Well, no, we have all these cases, 245 across the country. But that's at the very least, if you're here, you want to be kept up to date. That's why you're here. So I appreciate if you just please fill out the top half. We never sell out our material, our database to other entities. So you won't be getting things from other groups. We're very unique that way. We keep it all, and it's actually encrypted in our database. So we're very protective, very, very protective. Yes.
I have a theoretical question, and I'm just wondering, how something like this can even sustain itself and not collapse totally on itself. So, if you have a child that identifies as the opposite gender, you can't discriminate against that. But if the parents claim that it's their religious responsibility to care for the child, wouldn't any legal action against them, wouldn't that be discrimination against a religious affiliation there?
Oh yeah, that's the battle.
So
that's what
how did the two coexist?
Yeah, okay. That's the problem, because up until now, case law pretty much says that the religious beliefs of the family are to be respected. And so, for example, there's a case dealing with a family, and the modern medicine said we need to do this procedure, and the parent says no. But we're not going to do that. And the court said parents have great deference when it comes to the medical care of their child. However, if it results in that decision is likely to result in the child dying, for example, based on what the Western medicine is saying.
Blood transfusions or something.
Yeah, blood transfusion. Then that trumps that's a compelling state interest that trumps the fundamental right of the free exercise of religion for the family. So that's how it's been. Now with this, we have that same strict scrutiny of protecting gender identity.
But so that's not a life or death issue, though.
No, it's not. But the point is, we've got a strict scrutiny protection for religion, but now we also have strict scrutiny protection for gender identity. Before it was down here, like rational basis, and then they've tried to move it up. But you're right, it's going to be it's going to be some interesting cases out there. And we at PJI, make no mistake, we are committed, as long as we're existing, to fight and defend your rights as a parent and religious freedom. We have more cases out there, I believe, than any other organization when it comes to parents' rights issues and things like this. So we're here, and we're here to serve you guys. And I'd love to keep you updated. So once again, if you could please fill out that. We'd love to, I really appreciate it. And also, we have free resources on our website as they come out. Like we just came out with something today, a resource that has a list of books. You've heard of like garbage in the public school libraries? Well, we came out with a whole list of good books, positive books, and an explanation on legally how to get them in your public school library. That's just an example of the kind of resources that we provide, in addition to litigation, legislation, and church empowerment. Any other questions? Or I don't want to take, we're almost out of time. I think 8:30 is we need to, right? I don't want to take too much time.
I would just like to say, first of all, thank you for coming and for all the work you do. But I will also say that there is a revival coming in our country, I believe. I believe there was a big shift in the election, but what we desperately need is an outpouring for revival in young people and an awareness of the Most High God. And
Yeah.
what we're really looking at more than, and the focus is this, but the real focus is, Lord, would you come and be glory? Lord, we pray for an outpouring.
Yeah.
And with that shift in attitude will come people looking and saying, this is wrong.
Yeah. Well, I'm glad you mentioned that, because going back to how we first started, we can litigate, and we're keeping open doors by God's grace.
Yeah.
And I've seen His intervention in our cases time and time again. But at the end of the day, I was on a radio show and they said, Brad, what cases do we need? It was a secular, conservative show, but secular. Law, what case do we need to see passed to really turn this nation around? I said, there's only one thing that'll turn this nation around for the long term. Because what is it? Tell us, Brad, what is it? And I said, that's for people throughout America to come to a personal, real relationship with the Lord Jesus Christ and to become a follower of Jesus.
Amen.
And you know what I heard next? Nothing. It was dead silence. On radio. You don't have silence on radio. And then I hear what else? I said, long term, that's it.
That's it. Yeah, amen.
And then I said, now, we can talk about some short-term measures to help keep the dikes from breaking. And yes, let's talk about those. So I let him off the hook some. So we did. But at the end of the day, that's the most important question in every individual, as far as I'm concerned. Do you know Jesus? Let me give you a little hypothetical on this. If we knew that tomorrow at 1:30 p.m., and no one knows the day and the hour, I get that. But we knew that for a fact that Jesus was coming for some reason. Maybe all the pastors had dreams and visions all across America, and they all said that tomorrow at 1:30, yes, tomorrow at 1:30. And we're all convinced it was going to be tomorrow at 1:30. What would you be thinking and feeling if you found that out? Would it be, awesome, cancel our trip to Hawaii, we need to call your Aunt Myrtle, I don't know if she knows the Lord, Would it be just like, yes? Or would it be, oh shoot, I don't know if I'm going to make it. Right? And that could be because you may have this dark closet in your past. And by the way, we all have a dark closet, for the record. That's why Jesus died on the cross, right? But you say, but this dark closet is so bad, it's so shameful, it's so disgraceful. How could God ever forgive me for this? Because I can't even forgive myself. You know what we're really saying? This is what we're really saying. It's like walking up. Is there a cross around here? Right behind. Oh, the black one. Okay, good. This is so contemporary church. Okay. Anyway, so there's Jesus on the cross. And he's dying on the cross. He's nailed to the cross with a crown of thorns. He's bleeding and gasping in pain and agony to bear our sins out of love. And it's the same as walking up to him and saying, nice try, Jesus. But you see, for me, that's just not good enough. And I believe his response to that was very clear when he said, "It is finished."
Amen.
And all we have to do in humility is to recognize we can't do it on our own and receive what Jesus did on the cross unconditionally as our sole source of forgiveness and salvation and reconciliation with God. And when we do that in faith, he separates our sin as far as the east is from the west. He writes our name as written in the Lamb's Book of Life. We're given an eternity, a promise of eternity, but not only that, he comes to never leave us or forsake us, even to the end of the age. We become a child of the living God. And all of that can happen right here and right now.
Amen.
Now, when I just shared that, there may be someone out here who sort of felt something like just tugging on their heart just now. Because maybe you do have doubts. Maybe you are unsure. What? That's the most important question. You know, if Jesus was to come, would you be ready? Would you? If you're feeling that in your heart, it's not me. It's probably the Holy Spirit saying, now is the time.